Hi, everyone. Thank you for joining us today. As you're coming in the webinar room, I want to welcome you. My name is Marche. I'm the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We are thrilled to bring you this educational presentation today. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenters will answer those queries during or after the presentation today as time allows. If you ask a question in the chat box and we're not able to get to it, go ahead and leave your contact information as well, and we're happy to reach out to you after today's event to make sure it gets addressed. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. Well, I'd love to introduce you to today's presenters. Sheldon Sweeney is extremely passionate about helping families and their children with special needs. He connects with them on a personal level because his youngest daughter has Down syndrome. He knows the extra demands that this puts on families, as well as their need for high quality planning. Sheldon understands the advocacy needed for providing for children with special needs, and he has an organized network of professionals who serve these families and is regularly asked to speak at school districts and organizations such as the Washington State Fathers Network, the Issaquah, Tahoma, and Kent school districts. Sheldon has taken a unique path to arrive in the financial services industry. After graduating from California Maritime Academy with a BS degree in nautical industrial technology, he worked in the industrial marketplace for many years. Ultimately, his love for client service led him to a career in financial services as a protection specialist with a major fraternal insurer. However, he couldn't fully service his clients with their limited insurance options. And Sheldon enjoys helping families who are planning for retirement, as well as business owners who need advice on creating an exit plan while protecting the business they have built. Starting in 2012, Sheldon built his business at Pacific Capital Resource Group, Inc. in Bellevue, Washington as a financial advisor, establishing niches. Sheldon then received an opportunity to move his business to Snyder Financial Group as a wealth advisor in 2019. Sheldon holds 3 designations: the Chartered Special Needs Consultant, the Retirement Income Certified Professional, and the Chartered Financial Consultant designations. He is also life and disability licensed. And Sheldon, I know people can't see you because I'm talking right now, but if you can just go ahead and say hello so people can see your face, and then I'll go ahead and introduce our second presenter.
Okay, thank you, Marche. Hello, everybody. It's great to be here today.
All right, very good. And our next speaker is Suzanne Burke, and she's a founder and member of Assure Law Group. For over 20 years, Suzanne has worked exclusively with individuals and families as they plan for the future and take care of the present, focusing on multi-generational planning, planning for owners of closely held companies, and planning for individuals with special needs and the families who care for them. Suzanne recognizes that estate and personal planning should not be a one-size-fits-all proposition. She takes an individualized, multidisciplinary approach to addressing her clients' unique circumstances, needs, and goals. Suzanne's passion for families reaches beyond these services Assure provides to its clients. Over the years, Suzanne has been deeply involved in both local and international efforts and organizations that support women and children. Having a son with autism spectrum disorder, Suzanne regularly contributes to causes that support individuals with special needs and their families. And Suzanne, why don't you go ahead and come off of mute and make sure people can see you?
It's good to be here today, and I'm looking forward to the discussion. Thank you, Marcia.
All right. Well, I'm going to go ahead and turn the time over to Sheldon first, and we're excited to have hear what you have to say.
Okay, thank you, Marche. So as we introduce the program today, since I'm a financial advisor, there always is a level of disclaimers that need to be talked about. And Marche mentioned some for advice chasers, but since we're going across different state boundaries, and more specifically, every family has unique planning. So I wouldn't want anyone to go out and implement anything that I specifically talk about today until they got good financial advice or legal advice on that, because every family needs, it's never a cookie cutter, it's broad. We're going to kind of stay high level today. And then, Marcia, did you need me to cover anything else on this particular?
No, that's fine. We can go ahead and launch into the content.
Okay, perfect. Okay, so with the basics, I think also just to getting to know who I am, as Marcia mentioned, my youngest daughter, who's now 20 years old, has Down syndrome, and I have 5 children in total who are all young adults at this point. And then it's always fun to do a presentation like this with Suzanne. We have a lot in common. Our families know each other. Our families are within the same school district, so we have lots of back and forth. So that's a bit basics about myself. And then when we're talking about basics of financial planning, especially for planning for families that are in our special needs community, there often are not constraints, but sensitivity to anything that will happen that could be, tragic. We just got to make sure we're taking care of basics. And I consider the most basic financial planning tool is what we call protection. And protection in financial planning terms has to do with the different types of insurance. So life insurance being kind of the primary one. There's one called disability income insurance. And then we get into the car and home and liability, medical, health insurance. We want to make sure that these insurances are always reviewed at different points in our lives. None of these insurances are set it and forget it. They need to be reviewed. You could be at different price points. There's a lot of intricacies to this. Each one of the bullet points on the screen is actually an entire topic within itself. I think one of the areas that's misunderstood sometimes is this area called disability income insurance. So that's an insurance that individual could take out that's protecting their stream of income, their cash flow, the type of work they do. You can actually insure that. Sometimes you'll have a group coverage that can be utilized through your employer if you're owning your own business, or even if you have that group coverage, you can go out and get an individual policy on top of that you will own. It's like owning an individual life insurance policy. It's separate from the group coverage, and no matter what job you change to. So a lot of professionals use disability income insurance, and it is specifically designed to cover your type of work that you do. So that's worth getting some extra advice on. I think that's all I've got on that.
Yeah, let's go ahead and talk about basics for estate planning. So switching over to Suzanne here.
Great, thank you, Marcia. So as we talk about estate planning, typically, again, like Sheldon mentioned, we're talking about some basics that we advise most clients to address as they're, looking forward to planning their estate, especially when you have individuals with special needs. Those types of things are going to include estate and legacy planning, maybe also include guardianships, disability benefits, special education and vocational training, and special needs trusts can all be a part of that estate planning basics. The reasons why we put an estate plan in place are things most of us have encountered in our daily lives. We want asset protection for for what we've built and grown throughout our lifetime, so that we can pass that on to our loved ones. Especially in the context of special needs planning, we want to make sure that our loved one is cared for throughout not only our lifetime, but their lifetime as well. And then the legacy planning goes to those families who may have family wealth that they want to pass down, or companies that they would like to see future generations manage and handle after they are gone. And there are certain things that we can do to plan for their estate so that there's a smooth transition of that business interest to the next generation, while still, again, dovetailing into the next point there, while still maintaining some tax planning benefits. Anytime we set up an estate plan, tax planning is going to obviously be something that we want to address as well. And as Sheldon mentioned, we're talking across state lines, so you would need to speak with an estate planning attorney in your area or your state to know what those tax ramifications may be specifically to you. Everybody is, there's a federal exemption amount that everybody is subject to. Fortunately or unfortunately, depending on how you look at it, that exemption amount is significantly higher than it used to be. It's above $11 million per person. And so most of us aren't going to run into tax planning issues from an estate planning perspective at the federal level. However, as I mentioned, it can vary state to state, and you'll want to speak with a professional in your state to know whether you may need to do some tax planning within your state if there is an estate tax that is levied against an estate when someone passes. The last there is for disability planning for those of us who have special needs children. And as Sheldon mentioned, he has a special needs daughter, and I have a special needs son, and five children total. And so that's certainly a concern for me, is looking out for him and his future, not only financially, but also in terms of who will care for him and where he will live, these types of things that we can address to some degree within the estate plan, making sure that we are protecting any disability benefits that a loved one might be entitled to, while still allowing them full access to resources that we would like to provide to them upon our passing. And I believe that's it on that one. Last wills. Most people, this is the type of estate planning they are most familiar with. It's really the basic estate planning building block. There are other types of estate plans. Many have heard of revocable living trusts, irrevocable living trusts, and so forth. But a last will, again, speaking across state lines, is generally the basic building block for estate planning. And the things that a last will can accomplish are it disposes your assets once you pass. So an estate plan can be incredibly flexible, and a last will is no different. You can actually determine how you want your assets distributed and in what percentages and at what point in time. So it really can be tailored specifically to you and your needs and the needs of your family and loved ones. You can appoint a legal guardian for your minor children. This is certainly a concern. I'll have clients occasionally come in and say, well, do I need to worry about estate planning at this point in time? I don't have any children. I maybe am even single. And I always tell them, it's a good idea to put an estate plan in place. And once you do have children, then it's going to be very important to put that estate plan in place. And that last will is the place where you're able to designate who you'd like to have act as a guardian. Typically, I tell clients who ask, who should I name as my guardian for my minor children? I do let them know it's a person who, or individuals who you would see raising your children in a similar manner that you may raise them, who may have similar values, whether that be, religious or simply moral. It's a good idea to choose someone that would raise them very similarly to the way that you would raise them. Also, someone who they're very familiar with. The next thing a last will can do is it authorizes your personal representative or your executor to negotiate or pay off any debts of the estate. So when we have a last will, typically what we see is you'll take that last will and walk it into court, and you'll go through a process that in most states is known as probate. And so once that personal representative or executor takes that last will into court and probates it, they then have the authority to begin managing your assets and doing these next bullet point items here. They can negotiate and pay off any debts, as I mentioned. They can file any tax returns that may be due, whether those are estate tax returns or individual tax returns. And they can maintain and defend against any legal claims that may arise. This could be in any number of ways, whether that's a contest to the estate plan or ongoing litigation that an individual who has passed away may be engaged in. And ultimately, and the biggest job that they have is to distribute assets to any beneficiaries that you've named within your last will. Powers of attorney. So this is another one of our building blocks that we talk about, and it's somewhat bread and butter. Each state is going to be a little bit different in how they, or the name for this type of document. But the power of attorney, you are basically allowing someone to step into your shoes. They are acting on your behalf. Usually this is going to happen upon incapacitation, but it can, a power of attorney can be put in place immediately if you say, there's a situation where I may want someone to step in and act either financially or for my healthcare decisions immediately. And I can give just a brief example. I have some clients who have moved overseas, and it was a concern for them because all of their assets were here in the United States. And as we talked things through, they said to me, Suzanne, what do we do about managing those assets from a different country? What is the best way to sort of handle that? So we talked about the powers of attorney and who they felt might be best suited to step in and take over for them financially so that they could continue to manage those assets through this individual. And so we did end up putting in a power of attorney that was not reliant upon incapacitation. And so that's when that can really be beneficial, even when it's not under an incapacitation. As I said, it allows that person to sort of step in and make those decisions for you. And within your document, within those powers of attorney, you can give significant direction about what you would like that individual to do. Powers of attorney can also be prepared to support our disabled individuals. And we'll talk about this a little bit later on as we get into some guardianship discussion. But there's sort of a sliding spectrum of options as far as individuals with disabilities and what they can put into place to have individuals help them. And one of the least restrictive ways to do that is a power of attorney. So if we have someone who has a physical disability, but not necessarily a mental disability, this would be a good tool to use. They would have the capacity to go in and execute this with an attorney and sign that and have another individual assist them. On the other end of that spectrum, where we've got the most restrictive, would be a formal guardianship through the courts. So as I mentioned, this can be a type of protective arrangement for those that need it, whether, as I mentioned, under a disability, or even those who may just need a little bit of assistance in managing assets and making decisions. So there's several different types of powers of attorney. And again, the titles of those may vary depending on the state that you're located. Typically, one will address financial affairs and the other will address healthcare issues. And so with the financial affairs, you can actually, again, tailor this to exactly what you want that individual to be doing. If there are certain accounts you want help managing, or maybe a rental property. I had a client who said, I'm perfectly capable of managing most of my assets, but I do have a rental property out of state that I would really like some assistance in managing that. And so we were able to craft a power of attorney for them so that they could focus specifically, this individual could focus specifically on that piece of real property and assisting in managing that and paying taxes and so forth for that property. Powers of attorney can be both durable and non-durable. What that means is, and we talked a little bit about it, it has mostly to do with incapacitation. If you have put a power of attorney in place and you want that to last, even if you become disabled, that's what we call a durable power of attorney. If you say, I'm going to put this power of attorney in place, but I don't necessarily want it to carry on into incapacitation, that would be a non-durable power of attorney. We also have what we refer to as immediate or springing. And it ties into what we spoke about a moment ago. We can actually put these things in place immediately or have an immediate power of attorney, or we can have a springing power of attorney, which springs into place once a disability occurs. So people can set this up. It's a nice way to provide for the future. Nobody plans on incapacitation or disability, but it can be a nice safety net in case that does arise. They can also be, as we talked about a little bit, as more limited or general. You can really drill down into what you want that individual to do, if they're going to be managing specific assets or just broadly managing your overall portfolio, or with healthcare decisions, if you want to put in their hands certain healthcare decisions and not others, that's also a possibility.
And I thought, Suzanne, before we go from this slide, I thought of I've referred families to you before where there's young adults like that have maybe bipolar. And if they're
Yes.
out of the house or maybe even at college or something, it's another good place to, like under our special needs umbrella, right? Like
Right. Thank you for chiming in on that, because Sheldon, we do see even with college age children who have not got any kind of disability, parents are back at home with the state where they set up the bank account or with the primary care doctor. And the parent, if they put those powers of attorney in place, can then utilize that on their end to still help and manage assets as that young adult begins to figure out these parts of adult life.
Okay, I can take this one here, and I guess our point also, and as we go back and forth with these slides, is there's a lot of interaction and crossover between financial planning and then good estate legal planning. So you'll see that come to play as we move through these. So when I describe the basics of financial planning, I tend to talk about three categories, which are protection, savings, and growth. So we touched on the protection area, which is largely to do with insurances. The next level up, the next building block is understanding savings. And especially for families with special needs, I would always recommend a higher amount of emergency cash reserves, just for a benchmark on that. Usually it would be anywhere from 3 months to 6 months of expenses that are saved away just for emergency purposes, but depending on the level of care for your child. And I guess maybe just another definition here, I tend to talk more about children that are in the category of my daughter with Down syndrome, where there's cognitive impairment, where they really aren't going to be able to do things on their own a lot. So you'll notice I'll give more examples in that category than someone who might have like a mild level of autism. So I tend to lean into more planning of more severity, especially of cognitive impairment. But if you have a child that has a cognitive impairment, plus they need apparatus, plus they need maybe some machines to support them, or expensive medications, you'd want to even increase your, it's not uncommon for a family to have 12 months of cash that's just set aside. Of course, this depends on each family. And then the foundation or the principle of financial planning is that you can, if you have enough emergency reserves to go to, it tends to keep you from putting money on a credit card, which could get hard to pay off. So it keeps you out of debt, keeps the family out of debt. And a benchmark, overall benchmark of savings is 15% of income coming into the household. And that 15% can be spread across your long-term retirement savings, so your 401k plans and such, your in between savings goals, and the emergency savings, but broadly across all those categories, 15%. And then when we talk about the goals around these different level of savings, that short-term category of cash reserves is that area typically that has to do with emergency savings. Midterm has a lot of discernment around, are we going to invest this money? Are we going to expose it to the stock market? And if that stock market exposure is less than 10 years, we're going to put a lot of thought into that. We're going to lean way more towards a conservative style investment. Whereas in long-term retirement, and that would also be described in terms of timeline, so 10 years plus is your permission slip if you have a tolerance for market volatility, and you would have figured that out this year. But if you have that tolerance, 10 years plus is kind of the timeline that we would generally look at. If it's beyond 10 years, you can experience many different economic cycles, many different market cycles. So the midterm can be more challenging. Again, not specific device, but a lot of times if a person has a 3-year savings goal, I'm usually going to recommend not to invest that money as an example.
All right, let's move on. We're going to talk about trusts now.
And as I mentioned earlier, there are multiple different types of trusts, and many of us have heard the term trust thrown around. I'll occasionally get clients in who said, I've heard that everybody should set up a revocable living trust, that last wills are sort of a thing of the past, and the trusts are the thing that we need to put put all our eggs in that basket. And I always let clients know it really depends on your individual circumstances. There are certain circumstances in which you'd want to utilize a trust, or it may be most beneficial for you and your family to utilize a trust. So when we talk about a trust, what is that? And just getting back down to the basics, a trust is a mechanism by which you can hold and manage assets during your lifetime. And that's really one of the biggest differences between a last will and what we call a revocable living trust as far as estate planning goes. As you're doing your estate planning, if you utilize a last will, assets are not going to be transferred to beneficiaries until you pass away. Not so with the trust. With the trust, you're actually able to transfer those assets immediately into the trust, have that trust begin to manage those assets, and then when you pass away, whoever you've named as a successor trustee on that trust is able to seamlessly step in and begin managing it and distributing those assets. No court authority or interjection is needed when we're utilizing a trust, which I know for a lot of my clients, it can be very beneficial. I had a client come in a couple of years ago and said, I know that I don't have any assets that would necessarily warrant a trust. And we had walked through his circumstances and he laid that out. And we said a last will would probably work just fine. But for him, he had actually walked through the process of probate with both of his parents and felt that he did not want to have to put his family members through that. He did not want them to have to go through probate and go into court and ask for permission in order to manage assets, sell assets, or distribute assets to beneficiaries. And so that can be a very useful tool when we're talking about trusts and trust planning versus a last will. Another type of a trust that I work with clients often on, as I am often in the special needs planning arena, and Sheldon and I both are very familiar with this area, is special needs trusts. And so with our special needs families, they are really looking for ways to plan and prepare financially for their special needs loved one. And that can be now or in the future. And I think it's incredibly important to always have a forward-looking eye when we're talking about planning, whether that's financial or legal for our special needs loved ones. When my own son was very young, obviously we did not know what his capabilities were going to be. And so planning looks different at different stages. And so it's certainly something that we should revisit. But with the special needs trust, it can be a very nice tool to allow our special needs loved ones to hold assets for their benefit without disqualifying them from disability benefits. And I'll drill down on that just a little bit. So for most of us, we know that special needs individuals can access disability benefits, but only if their asset levels are below a certain amount. Typically that's $2,000 per individual, which is incredibly low. So we know that special needs individuals can't hold assets in their own names. And so as we look to plan for them, we really need to sort of find a workaround for that. And that's what that special needs trust does. We can take assets out of that individual's name while they can still remain a beneficiary of that trust and receive assets from that trust. So there are two types of special needs trusts that we talk about. And there's some fancy legal terms for them: inter vivos trust and testamentary trust. But I'm going to give you the easier way to understand that. So the inter vivos trust, if you hear that term, it just means a trust that you set up during your lifetime. So once you sign those trust documents, that trust comes into being and you can begin to put assets into that trust immediately. This type of trust can be very helpful for families who maybe have significant assets and want to begin to move money out of their own estate for tax purposes and move that over into a trust for their loved one. It can also be a great option if you have loved ones who want to leave money to your child as well through birthday gifts or Christmas gifts and so forth. Contributions can be made to that trust on behalf of your special needs loved one without touching their disability benefits. The other type of trust I mentioned, the testamentary trust, again, a fancy way of saying a trust that comes into being once you've passed away. And this type of trust, we usually embed that within the estate plan so that when you pass away and we're going through how those assets are to be distributed, a certain amount of the estate or a certain dollar amount or percent will be moved over into that trust for that beneficiary. And typically for my clients who maybe don't necessarily have extra income that they want to funnel into a trust right away, or if they have a special needs loved one who lives with them, and they say, I don't really think there's a need to have that separate trust set up at this time, since they're going to be living with me, we're going to be providing for them throughout their lifetime. The testamentary or trust that kicks in once you passed away may be a better option for them. And there's
Suzanne, could I add a comment
Sheldon,
in there
always,
just to kind of point out the overlap in how things work here, is that the use of life insurance in special needs planning is also very common, and it could go towards what Suzanne was speaking about, whether it's a testamentary trust. If there's not a lot of assets to put into that trust right now, you could name, right, Suzanne, either the estate or the trust as the beneficiary of that life insurance policy. So then you're paying premiums, which when that life insurance policy pays out, creates an estate, creates whatever amount of death benefit you feel is appropriate to feed that into that trust. So you don't have to feel like you have to have a bunch of assets to put in now. Some families don't have that. So the use of life insurance is very common. And there's one called a second to die policy that's very commonly used. So that's something to ask an advisor about.
Yes, thank you, Sheldon. One other thing you might want to think about, or at least have in the back of your mind, is how those beneficiary designations are listed. Certainly does matter, and it can affect the scheme at which that money has to be distributed out and the time frame for that. So you just want to work with a financial professional as you structure that. Thank you, Sheldon, for those comments. I always appreciate it. So the last thing I wanted to say about the special needs trusts is we have first person and third person special needs trusts. And really all you have to know here is who's funding the trust. With first person special needs trust, it's going to be the disabled individual's money. So that's going to be money that would come maybe from a settlement, or if the disability were later on in life and they already had an estate, you'd be able to put money into that first person special needs trust. Keep in mind, first person special needs trusts are irrevocable. They cannot be revoked once put in place. And so that's important to note. Third person special needs trusts, again, pretty self-explanatory. It's going to be a situation where it's somebody else's money funding that trust other than the disabled individual. And the trustee will step in and manage those assets throughout that disabled individual's lifetime. And it can't be used for anything. And this is where you really need to work with a professional for that special needs trust. There's specific language that has to be included in those types of trusts in order for it to be found valid. And one of the things most often you'll hear is to supplement and not supplant government benefits. Meaning if you're putting this in place, the money that's put into this trust is not intended to cover those things that disability benefits should already be covering, things like food and rent. Sheldon, I think this is back to you, but I know we do back and forth on this one. So
exactly. Yeah, let's just share this slide because it has implications both ways. So I just like to point out from a high level, these ABLE accounts are in that 529 area of tax code. So a lot of people recognize a 529 as a college savings plan. And what they did was they added an A after it. And it was a great nod towards our special needs community. There was a huge need for our especially higher functioning folks that still have that category of disabled, who do need to be having the diagnosis of disabled to qualify for an ABLE account. But this includes our deaf community, our blind community, where they're able to earn incomes, but if they're receiving government benefits, they can't exceed that threshold that Suzanne was talking about, like $2,000 in your net worth. It's crazy. It's an antiquated number. I wish it would get readdressed. But this is one way to plan around that, is using the ABLE account to put some earned income in that will be held outside of their estate. And I'll let Suzanne talk about how these ABLE accounts work very well, like partnered or right next to a trust.
Well, and oftentimes I'll have clients who say, I've heard of an ABLE account. Can you tell me what it is? And so I think it's important to note too, each state, ABLE accounts were set up at the federal level, but each state takes that and sets it up within their state parameters. So each state will have a different ABLE account. You don't actually have to stay within your own state's ABLE account. You can shop around and find the best one for you. It's, things like how that money might be invested and what the fees would be, and maybe some of the perks or options or things you want to look at. I have a client whose son was working, so he was earning money. And what they were finding, though, was he was earning enough some months not to qualify for the federal benefits, and other months he wasn't earning enough. And so they were constantly going back and forth with Social Security. So what we were able to do is work through and set up an ABLE account so that their son could contribute money to this ABLE account, which doesn't count, or it doesn't affect those means tested benefits. All the way up to $100,000 you can put into these accounts without having it affect benefits. So he was able to sort of use it as almost like a savings account, where he could put money in that he had earned in those months where he was earning more, and then draw off of it on those months that he was earning less to kind of level things out for himself a bit. Oftentimes, I will have clients say, ABLE accounts versus special needs trusts, which one would you recommend? And I always am going to say it's going to be very dependent on your own circumstances. And you definitely want to speak with a professional about that. But again, ABLE accounts are a nice option because they do tend to be less expensive than a special needs trust would be. There's just so many options for that. And one other thing to keep in mind, and Sheldon mentioned this briefly, you would have to have a disability in place in order to be able to qualify for that ABLE account. And the threshold is age 26. So you need to actually have been diagnosed with a disability, a qualified disability, by age 26.
Mm-hmm. Yeah, and I've noticed some people that can be a disappointment when they go to apply for it. But what I've seen that most states have a very strong customer service desk when you call into your state, and they will be able to help you answer all these questions. But it's also designed to be a do-it-yourself. Like you don't
Right.
need a money manager or a financial advisor. Money in the ABLE accounts is invested, so you should probably just, if you're not sure, or if you're serving as a guardian or something, check in with an advisor. But it's usually like small, medium, large in terms of investments. It's conservative, moderate, and aggressive. But when I go back to those savings goals, if that person has a short-term need for money, it's gonna be going in and out. Probably don't want to be aggressive with how you have those accounts in there. The biggest difference I've seen between states also is who the money manager is. Almost every state picked a different money manager. So if you want to shop around, the opportunity is there to shop around.
We did have a question that came in that's specifically about an ABLE account. So if your son or daughter has a 529 account, can you move those 529 funds into an ABLE account instead?
You can. That provision came up. It wasn't there originally when they set them up, but they did make that allowance. So if your child, they were born and you were an awesome saver and you got their college fund going and then found out, doesn't look like that's on the cards. What can you do with that money? They do allow it to, and that wouldn't cost any tax or anything like that. You just transfer it over from a college plan to a 529A.
All right, thank you.
Okay, Suzanne, this is another favorite topic. Suzanne alluded to this earlier, but we both have takes on this one as well. And it's probably second most boring topic. People don't like hearing about life insurance. They definitely don't want to talk about beneficiaries. But as a boring, like into the weeds topic, it's so important. I mean, one of the biggest mistakes I've seen in this area, tragically, is after a divorce. And the spouse that you don't want to receive that money is still on your 401k, your life insurance, your annuity. I mean, these beneficiaries are prolific across planning. And Suzanne and I, if you're going at it from a legal angle or a financial angle, we're always looking at this saying, no. Or just simply revisiting it. Like I said, revisit your insurance. You want to revisit these beneficiaries quite often if you bring a trust into the picture, or if it's someone that you don't want on there. And then in terms, I'll let you speak to about, whether or not a special needs person with disability should be named.
Thank you, Sheldon. And I think just from our discussion, hopefully it's pretty clear. We don't want to name our special needs loved ones in our documents specifically, whether that's in an estate plan or through a life insurance policy or a financial account, an IRA, those types of accounts, because we're all of a sudden going to be handing them money that's going to be in their name individually. And we discussed earlier what happens under those circumstances. Well, they're going to get kicked out of their benefits, and they won't be able to reapply for benefits until they spend down the entire sum that they've been left, down to that $2,000. So it can be very, very important who you list as a beneficiary designation on these types of accounts. And oftentimes Sheldon and I will work very closely with clients as they set up their estate plan. I can't tell you the number of times, and it's rather tragic when, I have a client come in on the back end who's walking into probate and saying, we need to probate this estate, and these are the assets, and they list life insurance policies or financial accounts. And lo and behold, we go in and look, and the estate is not named as the beneficiary, it's somebody else. And so you can put this wonderfully crafted estate plan, last will or trust in place. And if you don't address your beneficiary designations on those accounts, that money will not go where you intended it to. And so always on the back end, after you've put an estate plan in place, it's a very good idea to go in and review your beneficiary designations. Like I said, whether that be on life insurance accounts, bank accounts, financial accounts, any type of account where you're going to have a beneficiary listed. One important thing to note, and I just had a client ask this a couple of days ago. She said, well, I'd like my assets to go to this individual, but if not this individual, then I'd like it to go to these several individuals. Can I do that? And I said, certainly. You're going to want to work with your financial advisor or your financial institution, and you'll name what we call a primary beneficiary, meaning this is the person who's going to sit in that first spot to receive those assets. And then you can list a secondary beneficiary as well, so that if that first beneficiary has passed away, those assets could go to a second beneficiary. You can also name multiple beneficiaries together. So for instance, if you have children that you would want to inherit that asset, you could list all of those children and just simply say in equal shares to each of them.
Another common mistake I've seen is where a young man will name mom as their primary beneficiary, and we all love our moms. But after they get married, they forget that mom is still the beneficiary in their life policy, which should probably go to their spouse. So I think but these are, I've pointed out some bad examples, but the good example is that when you name that beneficiary, Suzanne, it's considered contract law, right? I mean, it doesn't go through probate. It goes straight out, which is awesome.
Correct. Those assets are non-probate assets, meaning they are not assets the court's going to oversee in a probate. And so for some clients, if they're trying to structure their estate in a way that they don't want probate, they don't want to have a probate set up for them, they can go in and list beneficiaries on these accounts, and it will pass straight out without being included in the probate. I will say one caveat to that, though, and I often have clients say, great, that means it's not taxable then, right? Because it's not part of my total estate. No, it's still going to be included in your overall estate. Simply by having it pass outside of probate does not mean that it's not taxable. Unfortunately, if you have a state estate tax or you've hit that federal threshold, those amounts are still going to be taxable.
And we will do this. You can also name beneficiaries on an investment account. I didn't list it under that bullet, but if you set up an investment as transfer on death, you'll see sometimes a TOD designation, and it just means it's an extra document that gets attached to that investment account, and it performs just like these retirement accounts that are listed, where it will still bypass probate. It's very efficient. It's a very good planning tool.
All right, I think it's back to me here, Sheldon, but certainly chime in if you have anything you want to add. So, often I'll have clients come in and they may have a special needs child, but they may have other children as well. And I know Sheldon and I both fall into this category. And how they say, how do we make sure that each child gets what they need? Each child has varying needs, and they may be different ages. I actually just worked with a client several months ago who had, he said he had two families because he had two children from a first marriage that were older, and then two children from a second marriage that were quite young. And he said, how do I go about addressing the needs for all of my children? And so this can certainly be a concern when we're working with estate planning for special needs, how do we make sure that we care for our other children as well? I like to explain to clients that it's like a piece of, it's like a pie. You have a pie, and this is your total estate. And the nice thing about any type of estate planning work you do ahead of time, you get to divide the pie in whatever means you see fit. You can give one child a giant piece and another child a small piece if that's their needs. And again, I have clients who say, well, am I going to have family members or children, beneficiaries who are going to be hurt if I leave them less? Please know that this is something that you get to determine on the front end what those needs might be. This is why it's incredibly important to review. And I always advise my clients to review their estate plans around every 4 to 5 years, simply to make sure that the beneficiary designations are correct, the percentages are correct, and everything is up to date. Because we all know circumstances can change and needs can change for our children. So one thing to keep in mind is, as I mentioned, you can structure this really any way that you'd like to structure it. You can leave more to your special needs child. You can set certain dollar amounts. I've certainly seen clients who say, you know, I'd like to go ahead and give a dollar amount to my neurotypical children and off the top, and then let's leave the remainder in the special needs trust for my child. Now, keep in mind with this type of special needs trust, if something were to happen to that special needs child and there's still money in that account, you can list a secondary beneficiary under that trust. So it wouldn't go to the government. It's not going to go anywhere you wouldn't intend it to go, but it would be available to your special needs child throughout their lifetime. And then if and when they pass, if there are assets still available, those would go on to another beneficiary of your choosing, which can be very helpful. I did also have an estate planning client very recently who came in the door and he said, you know, we've set up a special needs trust for one of our children, but we've had some good fortune. Our estate is worth significantly more now. And so we'd like to go ahead and cap how much we're going to allow that special needs trust to draw, because we don't see him really needing, more than a certain amount throughout the rest of his lifetime. And so we were able to go in under the beneficiaries and sort of carve out some more specifics with that, where we would say, we're going to put this much up to this much in this trust, meaning we may already have, for example, $100,000 in this trust at this time. Well, if and when the client passes, they can say, we'll go ahead and fund all the way up to $1 million into that trust, but no more. So it can really allow for some flexibility as needs change and as this child gets older. Then this particular client said, let's go ahead and set up some other trusts for my other children who were both neurotypical, because they were both minors at the time, and we all joke and say, well, do we really want to put, hundreds of thousands of dollars in the hands of our minor children? I can't speak for others, but I would fear that they would take that and go buy a fancy sports car and drive to Vegas and blow it all. So just being aware that you actually can structure that in a way that it can be held until such times that you feel your child might be ready. A typical structure for that might be a third at age 25 and a third at age 30 and a third at age 35. Typically in estate plans that I prepare, we also like to allow any trustee of any type of trust some latitude, because they may have circumstances that child will need some assistance, things like college or perhaps buying a first home. So we'll allow the trustee some latitude with that and then make final distributions, at certain ages. But I think the most important thing to keep in mind here is it's very customizable to you and your loved ones. It can really be structured in almost any way that you would like it to be.
And I think in the special needs planning world, with the different planning groups that I meet with, it's always emphasized to search for an estate planning attorney that actually specializes in special needs planning. There are a lot of very good estate planning attorneys, but there's very few that have special needs planning as kind of their primary thing or a distinct specialty. The rest, I think, could say, yeah, I could do that for you, but it's kind of going to be more of just a fill in the blank document. And that's not what, that should be a red flag. So when you're interviewing special need estate planning attorneys, find one that would sound like Suzanne, because you not only want to protect yourself with getting the proper planning, but they're going to know these kind of questions. So when she talks about customizable, if they're not experienced in dealing with special needs trust, they're not going to really know the right questions to ask you.
Sure.
Okay, this one like it's back to me. So on financial planning, I described the three broad categories are protection, savings, and then growth. So when we talk about planning for the future, that's under the growth area. When growth, I'm talking about that long-term savings as it matures, the 401k plans and other savings plans. That's what we do long-term planning towards. And this is where retirement planning would come in. In special needs planning, a lot of times we'll say it's retirement planning for three. And some families have more than one child with a disability. So it could be planning for three or more. And that's, it's a challenging topic. It can be charged with a lot of emotion, realizing that we're not going to live forever. So we need to plan contingencies. And how do we ultimately set our children up? And again, I'm kind of talking about what it's like planning for my daughter, that cognitively, she's always going to need guardianship. She's going to need someone looking out over her day-to-day and looking out over her money. But that's not always going to be myself and my wife. So how do we do that planning where you can actually have some kind of retirement and then make sure your child is taken care of? So some of the conversations that will start to enter into this might be independent living, and that's very different for each family, and the money can come from different areas. But it is good to start broaching that conversation about 3 years before you anticipate your child might be able to have some sort of independent living situation. It is going to vary state to state, but some scenarios might look like maybe a family with more means might buy a home and the other families pay them rent. So then we'll do some planning around that, or it could be using Section 8 housing. And then we figure out some different pieces of how families can work together. So then the conversation becomes what kind of roommates would work well together, and then what kind of families behind those roommates work well together, because it's very financially intertwined. But even presentations like this can tend to be a little overwhelming. So it depends where you are on the planning spectrum. If your child's under 10, don't quite worry about this stuff yet. But when they're in their 20s, and honestly, with independent living, I'm not even allowed to have that conversation with my wife. She doesn't want to talk about that yet. It's too emotionally charged. I like to plan stuff, so I try to keep my mouth shut, but it's looming out there. But any child that is cognitively impaired, no matter how to what degree, I do think they have a desire for independence at some point. It doesn't happen like our traditionally developing kids around 18. But probably as they get closer to age 30, there's going to be a desire that we become independent. So we want to ideally leave this world where our kids have a community of their own. They kind of get how to navigate. I think it's more tragic when parents live into their 90s and their disabled kids are in their 70s. That's really hard for that person to recover from at that point. So hard topic, very emotionally charged. Don't go there until you have to. Don't make your spouse talk about it unless you have to, but just want to plant a seed, consider it a seed to ponder.
I know we're coming. I just want to interject here. I had a couple of questions I do want to address. I want to acknowledge that we have been getting your questions. We are coming to the end of our time here today, and this is what I'm going to do. I'm going to go ahead and record those questions and make sure they get addressed offline. Also, we will be emailing you a replay of this event tomorrow. That will be emailed to the email you registered with. So, and I do want to be respectful of our presenters' time. So let's go ahead and finish up here with guardianship and final thoughts, and then we'll go ahead and close.
Sounds good. Thank you. So guardianship, we mentioned a little bit earlier that there's a spectrum of assistance that we can give our special needs loved ones as far as helping with financial and healthcare decisions. So the most restrictive type is a guardianship. This might be called different things in different states. You might have heard the term guardianship or conservatorship. Guardianship tends to have to do with physical care. Conservatorship tends to have to do with financial assistance. And a guardianship is a protective arrangement that's actually sought through the court. So it is a formal court proceeding where you have to go in and request that. The court will typically assign, I know in our state it's called a guardian ad litem, it could be called a court visitor, someone that will come in and speak with the individual who is going to be potentially affected by this guardianship. They'll speak with loved ones, they'll review medical records, and then make a recommendation to the court on whether they think a guardianship or conservatorship should be granted. Keep in mind the process looks different in the different states, and so it certainly may be a little bit different or different wording in your state. I will say that courts, especially where we are, courts have begun to lean very heavily on, or they've been very reticent to give away rights for people who may have some capacity, even any capacity. I actually worked with a client about a year ago who went in and he wanted to get guardianship for his daughter. And we went through the process, and the court visitor ultimately ended up saying, I think this individual has enough capacity that we'd like to try a different arrangement. And so we went into what we call a joint decision-making agreement. And so we'll see how that plays out for that individual, if they're able to get the help they need. If not, we went ahead and left that guardianship matter open-ended so that we can later go back to the court and say, hey, we did try this, it wasn't effective. We'd like to step on to the next stage and seek that. But know that courts are reticent to give away rights if there is capacity. Like I mentioned earlier, you can have both physical and mental incapacity. And so you may have a guardianship that's going to focus more on financial affairs or on personal care, depending on what the needs may be. If you have an individual who is mentally has capacity, but they may need some physical care with bathing or daily routines, that would be a situation where you might want to seek what we call a limited guardianship. And that would mean only helping with that care, that physical care. If you have an individual who maybe has capacity, as I mentioned earlier with a client who he can go out and work, he does not have full capacity with his mental issues, but he is able to get out and work, and he does hold down a job. And so for him, we went ahead and sought a full conservatorship. He needed assistance managing that money, but he was capable of his day-to-day care. So just know that there are different options, whether you're going to seek financial or personal care, and again, whether you're going to seek full or limited. When we say full or limited, again, it simply means how much control is the court going to give you? Are they going to give you control over every aspect of this individual's finances or healthcare? Or are they going to sort of carve that out based on that individual's capacity? It's with guardianships, it isn't a one and done. And I think that's important for our guardianship, those who are subject to guardianship, to know. It's a situation where the court will continue to revisit this. There's mandatory reporting requirements that might be annually, every 2 years, or every 3 years, depending on how that's structured for you. So the court is going to want additional information from you. If capacity should change, the court can go in and reevaluate that as well.
I think this is our last slide. And so I would love Sheldon and Suzanne for you both to comment on this one.
Sure. Sheldon, would you like me to go first, or would you like to have the first bite of the apple?
Yeah, I could take a first bite at this one, because I think this is what I was alluding to about when parents pass. So I'm going to talk more to the emotional aspect and the planning aspect, and then Suzanne can kind of address the probate and such. But I think it's just a reality that and it's a planning principle, honestly, right? You start with the end in mind. So a good estate planning attorney is going to be able to take you there. A good financial advisor will take you there. What does that look like when we leave this earth? I've seen very good planning, and I've seen just terrible infighting with siblings and all that kind of planning. So good planning would look like mom and dad left very clear instructions about, and they've interviewed maybe siblings. If siblings are going to step into the picture, they understand where all the financial assets are. They know how to access them. I've seen notes left to kids about, here's the CPA you should contact for tax, and here's where the spare key is kept, and here's the realtor you should contact to sell the house. So more detail, the better, and always in light of what is best for our child, what would make that smoothest transition for our child with the disability and the surrounding siblings.
Thanks, Sheldon. I think this is one that can be very emotionally charged, especially as we have adult children who are caring for aging parents. I have a client right now who is pushing parents to get their estate plan done because she recognizes as an only child that that's going to fall to her. As Sheldon mentioned, you can have anything from infighting to court contests over what was intended, what mom and dad intended. So the clearer the instruction, the better. I will say, I think having an estate plan in place is incredibly important because we mentioned probate, and what we talk about there, you can have either testate or intestate probate. What that means, testate means we've got a last will, we can walk that into court, we have clear instructions from mom and dad in that last will about what needs to be done. If we have to go through intestate probate, again, this will depend state to state, but it's a significant increase in the amount of time, effort, and cost. There are mechanisms by which assets can still pass to loved ones. It won't go to the government. I get that question a lot. If an estate plan is not in place, there is a mechanism, usually state by state, that will allow assets to pass to the individual's loved ones. But I can tell you from the other side, with the clients I work with whose parents have passed away and they do not have a last will in place, that end up in intestate probate, it can be a very stressful situation. And so one thing I would encourage is have that conversation with parents. Do you have an estate plan in place? If so, where is it located? And as Sheldon mentioned, getting some of that information ahead of time. I often advise clients to put together a list of somewhere, usually through a password protected file in their computer or with their safety deposit box that may have passwords and account numbers, not just for financial accounts, but even for things like Facebook accounts or Instagram accounts. Those can be incredibly hard to close down and very painful as you get reminders for those if they're still open. Unfortunately, those types of online media companies are very difficult to work with when there's a death. And so if you have passwords and you have account information and you have been named as the executor or the personal representative, you can go in and manage those without having to involve those companies. So that can be incredibly helpful and take a lot of stress out of the equation.
All right, folks, we have reached the end of our time here. We usually do ask for questions, but again, we're going to go ahead and address those offline. Thank you so much, everyone, for being here. I want to thank Sheldon and Suzanne for giving us such a great intro to this. I know that we could probably spend several more hours talking about these topics, but I do want to thank them for their time and for the organizations that have made this webinar possible today. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much. And we're getting thank yous to our speakers in the chat. We really appreciate that. And we hope to see everyone at another webinar soon. Goodbye, everyone.